In the pursuit of transparency and accountability, culture and policy are essential but alone, they are not enough. True reform also depends on the design and deployment of modern tools and procedures that embed candor into the operational fabric of law enforcement. While legal mandates like Brady and Giglio establish constitutional obligations, they must be reinforced by systems that ensure those obligations are met consistently, accurately, and automatically. In this context, technological and procedural innovations are not peripheral to reform, they are foundational. This chapter explores how new technologies and improved procedures can help institutionalize the duty of truth-telling among law enforcement officers and their agencies. It focuses on innovations in digital evidence management, officer tracking systems, internal oversight mechanisms, artificial intelligence applications, and training protocols. When thoughtfully implemented, these tools do not replace the human commitment to integrity, they support and systematize it. They create fail-safes, ensure consistency, reduce discretion where abuse is likely, and generate records that can be independently verified. Technology cannot reform character, but it can reshape behavior. And in a system plagued by silence, missing records, and selective memory, technological and procedural innovations offer something profoundly powerful: a verifiable path toward complete candor. Body-worn cameras, BWCs. Overview and evolution. The introduction of body-worn cameras has been one of the most visible and widely adopted law enforcement reforms of the last decade. Initially framed as a tool for protecting officers from false complaints, BWCs quickly became essential mechanisms for truth verification and accountability. By recording officer-suspect interactions, BWCs provide an objective record of events that might otherwise devolve into conflicting testimony. They have become central to investigations of use-of-force incidents, vehicle stops, and in-custody interviews. Policy gaps and best practices. Despite their promise, BWC usage remains inconsistent. Departments vary widely in activation protocols, e.g., discretionary versus mandatory recording. Storage timelines. Some keep footage for 30 days, others indefinitely. Public access. Few states require proactive release of footage. Officer review policies. Some allow review before writing reports, others restrict it. To maximize BWCs as tools of truth, activation should be automatic or mandated by specific triggers. Footage should be stored securely and for a reasonable period, especially when use of force or misconduct is involved. Officers should write initial reports without reviewing footage to preserve independent recollections and identify discrepancies. Footage related to serious incidents should be publicly released within a defined time frame. Impact on candor and culture. When used correctly, BWCs reduce false complaints and also reveal patterns of dishonesty in official reporting. Officers are less likely to fabricate or omit critical details when they know a third-party record exists. Conversely, when officers are allowed to deactivate or withhold footage, it undermines the very purpose of the tool. BWCs are not just about evidence, they are about embedding the expectation of honesty into every encounter. Digital Evidence Management Systems, DEMS. The burden of information. Modern investigations generate vast amounts of digital evidence: surveillance footage, body cam clips, dash cams, forensic data, phone extractions, social media content, GPS metadata, and more. Managing this information manually or in siloed databases leads to error, omission, and delayed disclosure, especially when exculpatory evidence is buried in the volume. Centralized and searchable systems. DEMS offers centralized platforms that allow secure storage of all digital evidence types, keyword and metadata searchability, access control logs and chain of custody tracking, integration with case management and court systems. For prosecutors and defense attorneys, these systems enable timely review and ensure compliance with Brady and Giglio by flagging materials that may be favorable or impeaching. Procedural integrity. DEMS can be programmed to automatically notify supervisory staff when certain types of evidence, e.g., use of force footage, civilian complaints, are added. They can also create immutable logs to verify whether officers have accessed, downloaded, or deleted files, making it harder to hide, manipulate, or ignore material facts. When combined with AI discussed below, DEM systems have the potential to revolutionize compliance with disclosure obligations by ensuring that nothing material is lost in the digital deluge. Officer Tracking and Early Intervention Systems, EIS. Monitoring credibility and conduct. A key procedural innovation in some departments is the implementation of early intervention system software platforms that track officer behavior, complaints, use of force incidents, and performance indicators to identify patterns of concern. These systems can flag officers for repeated civilian complaints, frequent involvement in high-risk incidents, inconsistencies between reports and footage, and high rates of suppression of evidence in court. Brady/Giglio integration. By integrating EIS with prosecutorial Brady lists, departments can ensure that any officer flagged by internal review is also assessed for disclosure requirements. This reduces reliance on informal communication and supports standardized reporting to prosecutors. EIS platforms should also include a record of judicial credibility findings, alerts for pending disciplinary reviews, automated reporting features to prosecutors and internal affairs, risk of misuse and oversight requirements. Critics warn that predictive or behavioral tracking systems can become tools of surveillance or bias discipline. To prevent this, officers must have the right to access and challenge their records. Oversight bodies should audit how flags are generated and used. Data must be contextualized. One complaint should not carry the same weight as a judicial finding of perjury. Properly implemented, EIS is not about punishment, it's about prevention and professionalism. Artificial intelligence, AI, and pattern detection. AI in evidence review. Artificial intelligence, particularly machine learning and natural language processing, can dramatically enhance a department's ability to detect patterns of dishonesty, misconduct, or procedural failure. Applications include report analysis, comparing narrative consistency across multiple cases, footage review, flagging discrepancies between spoken word and video evidence, testimony tracking, identifying contradictions in court testimony across cases, keyword alerts, detecting red flag terms like resisted, furtive, or non-compliant, used repetitively without supporting documentation, predictive applications, and bias concerns. The use of AI in law enforcement raises critical questions about bias, transparency, and accountability. Pattern recognition must be based on validated datasets and subject to audit. AI should never replace human judgment, but should act as a tool to prompt further review and ensure no stone is left unturned. Transparency is key. Agencies must publicly disclose how AI systems are used, how data is collected, and how officers are notified of findings. Oversight boards should review algorithmic outputs and assess whether they reinforce or reduce systemic bias. Modernize training and scenario-based simulations. Moving beyond lecture-style training. One of the most overlooked innovations in law enforcement is procedural, how officers are trained. Ethics training is often confined to legalistic lectures or annual PowerPoint modules. This does little to internalize the value of truth or prepare officers for the real-world pressures of dishonesty. Scenario-based training. Departments must invest in scenario-based training modules that simulate high-stakes decisions involving truthfulness. Examples include report writing simulations with competing incentives to omit or include exculpatory detail. Mock courtroom testimony, followed by feedback from prosecutors and defense attorneys. Bystander intervention scenarios, where officers must respond to witnessing another officer commit misconduct. These trainings should be immersive, frequent, and reinforced through debriefings that explore not just what happened, but why the ethical path was or wasn't chosen. Peer-led instruction and ethics mentorship. Officers learn best from peers they respect. Departments should develop ethics mentorship programs where experienced officers known for integrity guide newer recruits. These programs can counteract toxic subcultures, challenge the normalization of dishonesty, and promote a professional identity rooted in candor. Streamlining procedural safeguards. Standardized report templates. Officers should use reporting systems with structured fields that prompt documentation of exculpatory information, require explanation for any use of force or deviation from protocol, include automatic checklists for disclosure to prosecutors. Standardized reports reduce room for selective omission and ensure that all necessary information is captured at the earliest stage. Real-time disclosure alerts. Prosecutors and defense counsel should be notified in real time when officers are under internal investigation, have been flagged by EIS or added to a Brady list, have discrepancies between statements and digital evidence. These alerts reduce trial by ambush and enable early intervention, plea negotiation, or case reassessment. Integrating community technology. Citizen reporting portals. Communities should have access to secure, searchable complaint portals where they can report misconduct anonymously or with identity. Track the status of investigations. Submit supporting evidence, video, photos, witness info. Access summaries of substantiated findings. This fosters a two-way system of transparency and invites public participation in oversight. Open data dashboards. Departments should publish data dashboards that show number and type of civilian complaints, officer-involved shootings and use of force statistics, disciplinary actions and outcomes, trends in Brady/Giglio disclosures. Dashboards should be interactive, filterable, and updated quarterly at minimum. Conclusion. Technological and procedural innovations are not substitutes for ethics, but they are powerful enablers of integrity. They can hardwire truth into systems that have long depended on discretion, memory, and institutional loyalty. When designed with care and deployed with transparency, these innovations transform law enforcement from a profession defined by opacity into one driven by data, accountability, and professionalism. But technology is only as good as the people who use it. A body camera turned off, a database left incomplete, a report left unchallenged, each represents a decision. Reform means not just building better tools, but creating a culture in which those tools are embraced, maintained, and used to protect the public, not shield the powerful. Complete candor is the ideal. These innovations are the infrastructure. The next chapter will explore how these tools, together with cultural reform, can help heal fractured relationships between law enforcement and the communities they serve. I am a dedicated author and researcher specializing in the intricate nexus of technology, law, and government. My extensive body of work includes a diverse array of books, scholarly articles, and policy papers that delve into the evolving challenges and opportunities presented by technological advancements within legal and governmental contexts. Through rigorous analysis and insightful exploration, I examine how emerging technologies such as artificial intelligence, cybersecurity, data privacy, and blockchain shape and are shaped by legislative frameworks, regulatory practices, and public policy initiatives. My publications aim to bridge the gap between technical innovation and legal governance, providing comprehensive resources for policymakers, legal professionals, technologists, and academics alike. By addressing critical issues like digital rights, cyber law, technology-driven governance, and the ethical implications of technological integration, my work contributes to the development of informed and adaptive legal systems capable of responding to rapid technological change. I am committed to fostering a deeper understanding of how technology influences governmental operations and legal standards, and vice versa, thereby promoting the creation of robust, equitable, and forward-thinking policies. In addition to my writing, I actively engage with government agencies, legal institutions, and technology firms to offer expertise and collaborate on initiatives that ensure the responsible and effective implementation of technology in public spheres. My dedication to exploring and elucidating the intersections of technology, law, and government underscores my commitment to advancing knowledge and facilitating informed decision-making in an increasingly digitalized world.